Stuart Flashman for plaintiffs, John Toss et al.
Michael Brady, also for plaintiffs.
Thank you.
Michelle Young for the defendants.
Thank you.
Mark Packer for the defendants.
Thank you.
Tom Falens for the high-speed rail.
Thank you as well.
Ray Carlson for the amicus, King County Water District, Your Honor.
Thank you. Anyone else that we have? Anyone on the phone? All right. Mr. Flashman, I'll let you begin.
Thank you, Your Honor. So we are here today to talk about remedies for the authority's violations of Proposition 1A. These are at this point procedural violations. And I've identified in my briefing two major contracts that the authority has entered into that we feel are in violation of provisions of Prop 1A in terms of committing bond funds without having prepared a subsection D funding plan. We've also identified some other minor contracts that the authority is apparently entered into or is about to enter into, which again will also commit bond funds improperly. And it appears there's a small amount of money, although the authority may be able to provide evidence that that hasn't been spent, but it appears from the documents that we've received and presented to the court that there has been $4 million that may have actually been spent on construction from bond funds. Again, we think this is all improper. In addition, there is evidence that was submitted with a request for judicial notice from Amici Curiae, indicating that there are further expenditures expected. They are not yet finalized. They are basically for the funds I've already talked about have to do with what's called CP1. All in the initial construction segment. There are additional funds being looked at being spent for CP2 and CP3. Those are not yet commitments by the authority, so we're just flagging them as potential future commitments, but they are not anything at the moment. It's illegal. It's just concerned that they're essentially a continuing pattern. And I guess that gets me to what I see as sort of a theme here, and it goes back to really sort of an admonition that's been made by many people. It's been attributed to Will Rogers as well as others. And basically what that says is when you find yourself in a hole, the first thing to do is stop digging. And we feel that the authority doesn't seem to have gotten that, because based on your ruling on the violations of Prop 1A, we think the authority is in a hole. And we think the appropriate thing for the authority to do is stop digging, but they don't seem inclined to do that. And that's why we're here today. Basically, we feel the court needs to step in and say, if you need to stop digging, stop digging.
Let me ask you this, though.
Sure.
You have asked the court for remedies that involve a number of things.
Yes, Your Honor.
Why wouldn't it be sufficient if the court simply issued a remedy to the authority to essentially rescind the original funding plan?
Well, as Your Honor pointed out, the question is what are the real and, essentially the substantial and practical impacts of just issuing that writ of mandate. And as Your Honor pointed out, if you don't go beyond that, maybe there are no substantial and practical impacts. But the problem is that the authority is in the process of committing bond funds has committed bond funds improperly. And that goes beyond just the rescission of the funding plan. That's basically saying that there are additional violations that are ongoing. And those are violations in part because of the fact that they haven't done the funding plan. They haven't done the C funding plan or the D funding plan that need to be done before they can be committing money.
But isn't one of the difficulties here that we have this interplay between federal monies and state monies? And at least from the briefing that was done by the state, they're indicating that federal monies are being utilized as opposed to state monies.
Federal monies are actually being spent, but by spending the federal monies, and in particular, spending federal monies beyond, because of course the federal monies require a matching of state funds. And at this moment, the only state funds that are available that have been appropriated are the bond funds. So if the federal money is being spent and is requiring a state money match, and the only money available is the bond funds, essentially by expending federal money, they are committing bond funds to be expended.
Does the time frame for when the match has to occur impact that, though?
It can, and it depends on which of the two funds. On the ARA funds, they are, as you were front-loaded with the federal money. The state money can be spent later. But with the FY10 grant funds, that's not true. The two have to go together. You have to be spending in fact, actually, under the FY10 grant, they actually have to first spend state money and then get reimbursed with federal money. But they basically spend state money and get reimbursed for the matching share of federal money. So they're starting right off with spending the state funds, the bond funds, if they're using the FY10 grants. And again, as we pointed out in the briefing, the Fifth Amendment to the ARA grant says that the ARA grant is only supposed to be used in the Fresno and Bakersfield segment. All of the construction currently being contemplated in CP1 is in the Fresno to Merced section, which is not where the ARA funds are supposed to be spent. So the only federal funds they've got available are, in fact, the FY10 grant funds. And those grant funds require intermediate, and that's in fact require pre-spending of state money in order to be able to spend federal money. So there's a very strong commitment there, just even by signing the contracts, to saying we're going to be spending state money.
Ms. Eno?
Your Honor, addressing this issue would require us to know whether the court's going to grant the defendant's objection to the new argument and evidence that was presented in the reply brief, which was addressed by petitioner's counsel here.
Assume it's going to be overruled.
Okay. Federal monies do not commit bond funds for all the reasons that were stated in our opposition brief. First of all, as the court pointed out, the Bond Act doesn't restrict the use of federal funds. It only restricts the use of bond funds. Secondly, the grant agreements themselves do not commit bond funds. Under the ARA agreement, which are the only federal funds that are being spent now, there's a tapered match funding strategy that allows use of federal funds. Only federal funds are being used. And according to current ratios of the rate of federal spending to state spending, there's been more state spending than federal spending, and there will be no need to match anytime soon. In addition, there is no geographic restriction in the ARA grant, as petitioners assert. The purpose of, first of all, the parties to the funding arrangement believe that ARA funds may be spent to construct the entire segment, including the geographic section that is encompassed by the first construction contract, and the federal government has been funding based on that. So that is the party's understanding. Secondly, the purpose of the Fifth Amendment to the ARA grant was to go to this tapered match strategy to allow advanced spending of federal funds so that the authority could continue to advance this project while complying with the requirements of the Bond Act. In so doing, it is clear from the sections of the grant agreement that relate to the new funding strategy, which required as a component the preparation of quarterly funding contribution plans, the first of which is attached to the plan, that the parties intended to expand the grant to the entire section. Particularly important language is on page 83, which indicates that the work required by Attachment 3A includes 2 to 3 geographically based design construction contracts and 1 project-wide contract. The project is the entire ICS. In addition, if the court looks at Attachment 3A, Exhibit 3, which is the funding contribution plan, and looks at the uses for which funding is authorized, it will see a list under the reference DB, which means design build, of 5 contracts. The first contract is the State Route 99 contract, which we refer to in the papers as the Caltrans contract. The second contract is CP1, which we refer to in the papers as the 2-3 contract. And listed below that are contracts 2, 3, 4, and 5 to complete the entire ICS. The funding contribution plan has to be approved and was approved by the federal government. Therefore, it's understanding as well as the authorities that the funds are funds to be used for the entire program. In addition, that means that petitioner's argument that the FY10 grant, which doesn't have an advanced funding feature in it, are not the sole funds that can be used. In fact, those funds are not going to be used until after the ARP funds are exhausted, because there is a time limitation expiration date of the ARP funds.
What's the consequence to the authority if the court orders rescission of the Section C funding plan?
With or without invalidating the contract?
Correct, without.
Without. There's no effect to the authority because there's no real benefit.
So the plan means nothing?
The plan means everything, but you have to look at the circumstances in which the plan is required to be developed. It's part of a legislative process, and it was developed and presented to the legislature so that it could determine whether to appropriate funds to build high-speed rail. And to the extent that there are any protections for costs for taxpayers in that plan, they are exercised through the legislative process.
What about the fact, though, that there was non-compliance with the funding identification and with the environmental requirements? And that those were essentially prerequisites before you get to this Section D funding plan?
The authority's view of the Bond Act, well, first of all, the authority believes it did comply with those requirements. It was required to produce a funding plan.
Well, we've had that discussion.
And to meet the requirements. And it believes it did that when it submitted the plan. It didn't do it not believing that it had not satisfied the requirements.
Okay, but taking it from the perspective of the authorities now been found not to have done that, and that those things were essentially a prerequisite to the Section D funding plan, what happens if the court orders rescission of the C funding plan?
Nothing practical happens if the court orders invalidation.
So the authority can simply go forward?
The authority has an appropriation to build a project authorized by that appropriation.
Isn't there non-compliance then with Prop 1A?
There is not non-compliance with Prop 1A.
So
there is a finding that certain of the reporting requirements were not satisfied. However, the decision maker, the person who reviewed, the entity that reviewed that plan was the legislature, and it appropriated funds. It could have appropriated funds for another project. It chose to appropriate projects for the usable segment that was identified in the funding plan, but it could have said, we're not going to appropriate funds for that project, we're going to appropriate funds for this project. And then the authority would be bound to build the project that was authorized by the legislature, and the second funding plan would be bound to provide information that relates to the appropriation of the legislature. So the appropriation controls the direction of the project, and for those reasons, a finding in this court that there has been a failure to satisfy certain of the reporting requirements doesn't create a real practical benefit that could occur by invalidation of the subdivision C funding plan.
So your argument would be that the sole purpose of subsection C was to simply provide information and that there's nothing more to it?
It was designed to provide a lot of information to the legislature, more information than it would normally get in the routine public works project.
And if that information essentially is such that one can determine that there's non-compliance with the Prop 1A requirements in subsection C, it doesn't matter?
The duties are not for the benefit of TOS. The duties are imposed on the authority for the benefit of the legislature. And to the extent there is non-compliance with that, the taxpayers are represented through the legislative process. The funding plan process is a legislative process. Both the first subdivision C plan and the subdivision D plan are highly unusual legislative processes, but they are legislative processes.
So the fact that it was a proposition voted on by the voters becomes secondary to the fact that the legislature can just simply do the appropriation as it wishes?
The It is a bond act, Proposition 180 is a bond act. It was approved by the voters. There are performance requirements, design requirements, cost restrictions that govern how the plant projects can be built. However, the funding plan requirements are part of a legislative process that were designed to provide the legislature with maximum amount of information so that it could decide what to do and what it wanted to do. And it reviewed the funding plan, it reviewed a draft business plan, and there were hearings, there was an opinion. In fact, there was an opinion from Ledge Counsel to its client that it could authorize a smaller usable segment than the one authorized in the, or approved in the funding plan if it wanted to appropriate for a smaller segment. The legislature chose the bigger segment, and any subsequent funding plan has to be based on the legislative appropriation, which could have been different than it was. That's why violations of reporting requirements, Bond Act reporting requirements in a funding plan do not create an enforceable cause of action in favor of taxpayers like TOS.
Is compliance with Section D required?
Compliance is required.
And if there's non-compliance with Section D, what happens?
What is required is the production of a plan, and the production of a plan that meets all the subdivisions of that section. And as the court knows, there's a number of requirements for a subdivision D plan, including expert financial reports, etc. All of those have to be produced, and all of them have to be presented to the director, who makes a decision based on consulting with the legislature. I don't believe that there is a cause of action for producing a financial report that doesn't satisfy the requirement. That's up to those decision makers and the legislature as part of this very unusual legislative process.
But can the authority approve a Section C or a Section D report that are clearly deficient? Leaving the legislature out for a moment, can the authority approve such a report if it's deficient?
Well, without defining what deficient means, I'd have to say I really don't know. But it has to produce a report that contains information responding to all of the many requirements.
Well, let me just go one step further.
Can I just add, and if it produced a clearly deficient report in the court's view, it wouldn't get an appropriation. It could have produced a report that said, we have no identified funding sources. Give us an appropriation. I mean, clearly it wouldn't get an appropriation. The object is to provide as much information as it can in meeting those reporting requirements so the legislature can decide what it wants to do. And that's what it did.
Well, let's then go backwards a little bit. The environmental certifications were required to be accomplished. What the authority heard was that they will be accomplished. That was found to be a violation. The authority still approved it, submitted it to the legislature. The Section D report requires an update of something that hasn't even been done that should have been done. What does the authority do?
Well, first of all, the subdivision D plan doesn't address environmental clearances. Only the subdivision C plan does. And the subdivision C plan certification was that all certifications, all completions would be in hand before proceeding to construction. That was the promise, that was the certification that was made to the legislature. And the legislature viewed that as compliance with that reporting requirement, based on the statement of the authority and based on the law which requires that. No construction can start without those completions in hand. The purpose of that reporting requirement was to ensure that the authority would not try and exempt itself from any environmental pre-clearance requirements, and the legislature wanted surety that it would not. And to the extent, and it satisfied that requirement by stating that it would, and that concern and that purpose by stating that it would have all completions in hand before proceeding to construction, and the legislature accepted that.
So if the court were to order a rescission of the Section C funding plan, there would be no consequence.
There would be no
It wouldn't matter.
consequence. Correct.
No obligation for the authority to go back and re-adopt a new funding plan consistent with Section C?
There would be no obligation to do that. It was submitted to the legislature for an appropriation, and that appropriation is in hand.
Mr. Plasko?
So I guess I have to disagree. I think that it's worth bearing in mind that the measure that the legislature passed, that where they put the bond measure on the ballot, not all of that went on the ballot. And the provisions that we're talking about here did go on the ballot. So if this was only for the benefit of the legislature, why did it need to go on the ballot?